Mr. Orban.
Lady, the point I was on election contested elements.
And you're going to take us through two cases, I think.
Yes. I was going to show you briefly Agon and Moya.
Yes.
And then give you just bullet points on some other cases that have come up. Then a little bit on lack of remedy in Arbitration Act variation. On Agon and Moya, I want to make clear, so it's not thought that I'm trying to take cases out of context or inappropriately. Both are cases where the source was contractual, source of power was contractual. Agon, there's a quirk, which is the copy in your bundle is missing a couple of pages. So if you want a complete version, we've got
Yes, please, thank you.
It's in the middle, it's in the second or third page or something.
Yes, of course.
So this is a 1993 divisional court case that, at least in my bundle, was missing 2 pages, so I would make sure you've got a full copy. I've handed full copies, so I know friends. What we say is similar about it, and again, with all the caveats, each of these cases is quite different, but what's similar is the issue, the discussion of the consensual element of the jurisdiction, and that being a strong pointer in the mix on amenability. So we say this case is useful because of the way that consensual voluntary element is dealt with as an alternative to going to court, and that was a very significant matter, significant part of the decision on non-amenability. Despite the fact that you've got a statutory underpinning to the regulatory system through L'Outro, and the result, and it was woven into the into the government regulation. So, but I must stress, cases are not identical in any far from it. So the judicial review challenge is at the beginning. If you're on, if we're in the QB numbers, that's, or it's the report numbers rather, that's 89. Whereas LJ Insurance Company seeks judicial review challenge 23 decisions of the Insurance Ombudsman. So it's challenging the Ombudsman. And then the next paragraph, this raises jurisdiction in relation to the Insurance Ombudsman. So the issue of it, that's how it's described, the issue of amenability. And then the dispute resolution function is discussed under the heading of jurisdiction. Under that heading jurisdiction at E, one of 10 separate schemes for resolution of disputes, and it goes on to describe that and links that to Financial Services Act and statutory background, and goes on to discuss the statutory system and statutory schemes in some degree. And I note, just so pointing out all matters good and bad, over the page at 90E, you see, at E is clear from Dr. Farron's evidence, government played no part in the creation of the IOB, provided no funding, provided no part in the function of the IOB. So those are obviously matters against amenability. Then over the page, the claimant's arguments, which I won't spend really time to take you through. And indeed, over the next page, 92, the defendants' submissions about that matter. And the judgment, well, the decision starts at 93. In my judgment, necessary for the court, covers this case, only 3 authorities, Davies, Jockey Club and Briggs. And at the bottom of that page, the statement from Briggs, which I think we've seen before, is repeated there. And that takes me in relatively short order to, well, I should say actually that quote, the bottom of the page, at the bottom of 93, over the page it says, those words are equally applicable to the IOB. And then here, just a few paragraphs which encapsulate, which are the decision on amenability. And this is on 94, to be clear. And at B, the paragraph being the foundations of the IOB, you've got that. So, as I keep on stressing each case is different. You do have here elements of legislative scheme and also contractual consenting members. And that is what that is looking at B and C. And at the bottom of that paragraph, 4 lines from the bottom, I do not accept the judgments or that of Bourne J, or those of the members of the court in Datefin can be construed as contemplating that such a body as the IOB, even if it became interwoven in the government system, would be acceptable to judicial review. So this is looking at the issue of being interwoven in a system of regulation. And then you've got 2 paragraphs after that, one beginning since the Act and then the following one. And of those, I think this paragraph since the Act is important. Since the Act, as before, the public do not have to use the Ombudsman. They can instead sue insurers in the courts. Now, it's not exactly the same as our point, but it's not in a completely different universe to the issue of election, which I've been talking about. They go to the Ombudsman because it's not limited to pure legal considerations. In many cases, their prospect of success will be better, but they have the choice of forum. Likewise for insurers, those who choose to be members run a greater risk of adverse decisions. This follows the Ombudsman's terms of reference. And then 4 lines from the bottom, but the very reason why the IOB was set up in the first place was to improve the image of insurers by setting up a cheap, informal, independent procedure so that insurers not be regarded as sitting as judge and jury of their own cause to protect their own interests. So that paragraph is effectively, despite this being interwoven into the system of regulation, this element of choice or consensual element was a critical part of the decision on amenability. And then the following paragraph, IOB's powers of its members, still, despite the Act, solely derived from contract, it cannot be said they exercise governmental functions. The source of its power is still contractual decisions of an arbitral nature and private law, not set for judicial review. So 2 paragraphs there. The first one about the election, the choice element, and the second one about the source of power being contractual. Don't shirk away or pretend that we don't have that second point. My point is there are both points are emphasised there in the judgment, and we particularly rely on the first of those. Except in the case isn't exactly the same. So what I take from that, and again stressing that none of these cases are identical, is you have a system here of dispute resolution that has a consensual element to it, an opting in to it. Isn't an obligation to use it, and that voluntary element weighed heavily, or at least weighed in the sense you can see in the judgment there, along with the contractual source of jurisdiction. And that's despite the fact that you've got a legislative system under the Financial Services Act and a system interwoven into a system of regulation. The appellant seeks to distinguish Egon Life. I'll just give you the reference because we cover that in Skeleton, and it's set out there. On page 25 in our footnote, we have a detailed setting out of why the attempt to distinguish Egon Life isn't enough, and I'll leave you with that without covering it orally. It's always a combination of factors. You look at the judgment and you see the role it played there. So that was Egon, voluntary element, consensual submission. The other case, Muya, tab 63. I'll tell you what I take from it, and then we'll look at a few paragraphs and you can see whether that's borne out or not. What I take from it, it's another example of a consensual process, voluntary submission to jurisdiction. the investment ombudsman had no coercive power against the consumer. Consumer consented to the ombudsman acting, and that was an important factor in not being amenable within the context of a multifactorial test. And to show you the brief order, if you're in the case, paragraph 1, it's a judicial review of a decision of the Ombudsman of the Personal Investment Authority, Ombudsman Bureau. And 2 is the form of challenge. Paragraph 4 at the bottom, claimant made the submission that it cannot be regarded as consensual, and you've got the discussion of that, which follows, including Egon. And in the alternative, they argue that what was said in Egon was per incurium. And paragraph 6, they go through the 2 types of jurisdiction. And underneath those 1 and 2 is going through of the legislative scheme, the legislative regime there. And then over the page, paragraph 7 talks about the voluntary jurisdiction and what that covers. And in around the middle of that paragraph, they talk about they introduce the statutory backing of that voluntary jurisdiction continued until the 1986 Act. This is about in the middle of paragraph 7, and go on to look at that. And 8, compulsory jurisdiction, second line, not submitted, the jurisdiction is not amenable to judicial review. So that's a separate matter. We're talking about the voluntary jurisdiction. Then 9, they go through Agon. I'm not going to take you through that. And then to the conclusions. Apologies, that's a canter through, but I wanted to get to the conclusions as much as possible. That's paragraph 12. So, notwithstanding the guarantee of scope and argument claimant, able submissions, I conclude as follows, and then gives their gives the factors that were relevant there. 1, the jurisdiction and powers derived from a contractual relationship with the members. That's obviously not the same as our case. I say we've got elements of both, or a mixed picture in our case. 2, there's coercive power against the member firms, but in this case, the coercive power arises because the RSA is submitted to its jurisdiction. So there is that element there. And 3, PIAB, the Ombudsman Bureau that is, has no coercive power against the consumer, in this case the claimant, who consented to the jurisdiction. And that was the element of choice or election. 4, entitled to sue in the courts. 5, no monopolist power, only those firms who opt in. 6, not exercising governmental powers, providing a voluntary arbitration service. So that's a description of function, if you like, or activity. And the point I made earlier, that being dispute resolution isn't necessarily public in nature or governmental. And 7, far from being distinguishing Egon Life, more clearly an example of an exercise of consensual jurisdiction.
But also, the last part of that sub paragraph 7, the decision is not binding upon the claimant or any third party.
Yes.
Because they can decide they don't like the answer, so they'll go to court after all.
That is a difference, yes. And you'll see what's said underneath that about the dispute resolution process. And the conclusions of paragraph 14, not amenable. So broadly what I take from that is it's an affirmation of the analysis in Egon Life and the point on voluntary submission to jurisdiction. And here with the voluntary jurisdiction, despite the significant element of statutory regulation of these SRO, self-regulatory organisations, and statutory backing for the voluntary jurisdiction, it was still non-amenable for the reasons we've gone through, the combination of factors. And an important theme in that is the element of the voluntary nature of submission to jurisdiction. So again, not saying it's an all or nothing rule, or X therefore Y. The factor is given importance in this mix of points. Attempts to distinguish Moyer by the appellant. We've covered that in the skeleton, so I'm not going to repeat those. They're in the skeleton before. I think it's footnote on page 25. So that's Egon and Moyer showing you the way in which courts have looked at this element. And again, I'm not saying that it's a X therefore Y analysis. It's an important factor. Looking at how the court treats this issue or regards it in this context. I'm now going to give you some bullet points. I'm happy to take you to cases, but I'm conscious of time. So what I want to do now is address some of the things that were said against us on this point, particularly the OIA and Financial Ombudsman Service, FOS. What we said that the amenability of these bodies show, therefore, that similar bodies are amenable to judicial review. And there are cases associated with these, but I'm just going to give you the points. I'm happy to take you through it if needed. On the OIA, the point was made in relation to the case of Subaru Rima. And point we make about that is, if you look at what that body, the OIA, was dealing with, or the way it operated, you can see at paragraph 49G, the range of complaints was extremely broad, or is extremely broad for the OIA, and is not limited to contractual matters at all. The description of that, or the breadth, it's both paragraph 49G and paragraph 3, first three lines, where they talk about the breadth of complaints that can be made. The actual statutory provision isn't in the judgment, but if you want to know where this comes from, it's section 12 of the Higher Education Act. But the point is, disputes can be anything, or they don't have to, it could be a breach of a public law duty. So they're in no way limited to private law contractual matters. The OIA is quite different in that respect to this decision, which is about contractual principles. That's OIA. FOS, Financial Ombudsman Service. The FOS operates in a different manner because FOS itself is part of the scheme for financial regulation. for example, there are duties on the FCA to facilitate the exercise of FOS's functions, so it's part of the system of regulation. Its duty is to determine complaints in relation to regulated activities. So that's at least part of regulatory matter. It's not a jurisdiction to determine disputes over private law contractual rights. No, sorry, yes, thank you. It's also, in fairness, only binding if it's accepted by the complainant. And that's section 228 of the Financial Services Markets Act. So it's not in the nature of a domestic tribunal in that respect. We've made some of those points in our skeleton on page 30 if you want them. If you want to go back to them, that's paragraph 71, capital B, 3. We say the Financial Ombudsman Service is quite a different body in that respect, particularly the regulatory functions which it has and after decision making. I'm conscious that I haven't mentioned every case that was talked about yesterday. I certainly wouldn't have found to take you to or indeed cover in bullet point form. Well, I'm relying on the fact that we've covered, of the cases that were covered orally yesterday, pretty much all of them are mentioned somewhere in our skeleton, and particularly around paragraph 70 onwards, the paragraphs which follow there, where we go through the cases put against us. So for the point of view of time, I'm going to leave you with, to the extent I haven't covered the case from yesterday, I wouldn't want to be taking this any sort of concession, it's in our skeleton around.
The only one it would be helpful if you were to make submissions on is that single sentence in McLaren in the Home Office, which says that where you have, I think there's an employment contract or possibly an employment arrangement, and there's a superimposed body to deal with rights arising out of that dispute, that would normally be a public law function. Miss Richards relied on it, but not Mr. Shashikanth, I think. Do you know the one I mean, McLaren in the Home Office?
The case, yes.
The
point
I
of
can take you to the
sentence,
sentence if you give me the
tab 19.
tab 19. And it's page 409 too. 409 paragraph, in back to the canvas situations where an employee will seek judicial review. This will arise whether there exists some disciplinary or other body established under the prerogative or by statute, which the employer or the employee is entitled or required to refer disputes affecting their relationship. The procedure of judicial review can then be appropriate because it has always been part of the role of the court in public law to supervise inferior tribunals. Those two sentences, I think Miss Richards took us through them yesterday.
That's it. Around F, is it?
Yeah.
Where there exists some disciplinary or other body established on the property. So thank you.
Because what that is saying, it may be an underlying contractual employment dispute, but there's some superadded body derived from the prerogative of the statute, and it rules on the underlying relationship, and that's normally seen as a public function.
Yeah. I'm grateful. Well, one is looking to find whether or what the public law element is, that's as long as the tribunal has a sufficient public law element, so we're looking to see what that is. And earlier...
we will have, if the employer is the Crown, and here the adjudicator is Crown, yes.
And this, the beginning of this at 2, it's talking about employment relations. There can, however, be situations where an employee of public bodies is talking about issues of employment relations and arise where there is disciplinary or other bodies, so disciplinary or in that nature body. So it's talking about disciplinary matters or kin matters in employment relations for public sector employees. Those things do point in public direction. That's different from private law contract disputes. Because the paragraph read as a whole, I realise it's difficult because it's a long paragraph, but read as a whole, and it goes on later to talk about the alternative remedy of the industrial tribunal. So the whole paragraph, and the employer is the Crown, the whole paragraph is oriented around employment issues, disciplinary or other employment issues of public sector employees. And over the page, prison governors' disciplinary powers. So the paragraph as a whole, I say, is disciplinary or similar matters relating to public sector employees. And in particular, the first sentence on that in this block, which is at 409E at 2, there can, however, be situations where employee of a public body can seek judicial review and obtain a remedy which would not be available to an employee in the private sector. So if anything, the orientation is contrasting with ours. Obviously, Dr. Shashikanth isn't an employee in any sense. He's a private contractor with the NHS. But to the extent that this paragraph is looking at disciplinary or similar matters relating to public sector employees, that's to be contrasted with the remedies that would be available to an employee in the private sector. I'm not sure necessarily points against us. I think it perhaps could be used in our favour.
It's entirely unsuited to judicial review. This context.
And my ever helpful junior has also directed me to 838. AB. So the top of 838, whether or not he's employee of the Crown or has a contract of service or holds office under the Crown, he's entitled to bring private law proceedings if he has reasonable grounds for contending his private law rights being infringed, as his claims pleaded in advance, entirely unsuitable judicial review. Unlike continental jurisdictions, claims as kind, in civil proceedings, in which case it may be possible for them to be disposed of in the same proceedings. First issue, oh, there we are.
Thank you.
Then finally, to finish off amenability, just to make sure it's not lost, I'm sure nothing's lost, but just flag up our skeleton, page 31. I'm just going to show you the headings so it's clear that You can see where you find these points because they are all factors on amenability. And I'm not going to make substantive submissions, although obviously you would be assisted, but I'll point out where these points are. The final factors on amenability, page 31, paragraph 73, public service context. Doesn't make it reviewable. That factor, which is set out there in cases, adjudicates relationship with the Secretary of State. We'll probably put the matter too highly in the skeleton, but you see the general point. Tucker is still useful authority on that point. Then over the page, adjudicates reviewability when determining NHS contracts, and I've made submissions on that. And finally, at the bottom of that page, paragraph 78, no reviewability due to lack of different remedy. And it's that lack of remedy point which I just want to speak about for a couple of minutes. So on lack of remedy, it was a theme of my friend's submissions yesterday. There was concern about lack of remedy. We respectfully don't agree with that. The starting point is that whatever the court finds, a contractor with an NHSE, a contractor who has a non-NHS contract, the private law type, is far from being without a remedy. He has a number of remedies. He can sue in civil court. Alternatively, he can pursue an alternative to court through the dispute resolution mechanism, and thereafter we say through the arbitration. It's not the case that there's no remedy. Rather, the proper way to view this issue is that the contract is not just subject to as much supervision, enforcement of another private law contract, namely your ability to go to civil courts, but has more than you'd get from a private law contract in terms of your routes to remedy, because you've also got the extra option of going to the adjudicator. So the question, or rather the proper framing as we see it, is not whether a contractor should be left without a remedy, because we didn't think that's accurate. It's whether they should have a further remedy after they've elected to go to the adjudicator, they've gone to the adjudicator, and then decide that they also want to go to court after that as well, to seek judicial review.
You say within the contract there are choices, a choice has been made, and the nature of the choice is that if you go to court there are appeal processes, and if you go to the adjudicator there are not.
Yes. Well, there's the Arbitration Act.
Well,
but
yep.
that's another matter. And further, where you have private contracting parties that have provision for alternative dispute resolution, this is a form of alternative dispute resolution, alternative being to court, where the contracts have a mechanism for alternative dispute resolution. It's not exceptional or so unusual or contrary to principle to agree that ADR is the end of the road for the purpose of finality, expediency and clarity. In any event, it's not properly the test for amenability, because the framework and test for amenability should be source, function, those analyses, rather than a criterion that there must always be a remedy when one has when one is pursuing their rights in private law. Or another way of putting it is the absence of a remedy does not convert what we say is a private function into a public function. And that, we feel, is at least not inconsistent with Lord Justice Lewis's book and the part you were taken to on remedy. I've forgotten the paragraph number, but you were showing a heading or a paragraph on remedy, and without going back to it, in a nutshell, the message is, although if we want to know what's in the mind of the author, he's not too far away, the message is not strictly relevant, is the words used, though it may influence judges. And we agree that it's not strictly relevant to the proper analysis for amenability. Whether it influences judges, well, many things can influence without being relevant.
The short point is, this isn't public, full stop. It's dispute on contract, its nature is not there for public. And if that leaves him without any alternative remedy, be it arbitration,
That's
so
the scheme.
what? That's the one.
Yes. And you could have chosen a different scheme.
You didn't have to do it, yes. You could have carried on.
When one chooses the rights you have, you also choose the remedies you have thereafter.
Exactly.
That's amenability. The Arbitration Act, we do believe this point is right. But it doesn't take long to show you. I wouldn't...
How can a unilateral choice by one party to a contract mean it's an arbitration agreement within the Act? It's defined as where both parties agree to send it off for a particular form of resolution, and here only one party can choose. It's unilateral.
Yes. It's in the hands of the contractor, the GP.
And only the contractor.
Yes.
So can it fit the definition?
Well, we say, if we go to the factors, all other factors are there. They're all made out.
I'm sorry, section 6 is page 33. I'm not sure anything, arbitration is new to me. That's volume 2 when I retire. Oh my gosh, I've got no life. But in this part, an arbitration agreement means an agreement to submit to arbitration present or future. And an agreement means something that both sides agree with. You can't have an agreement when it's a unilateral choice.
Well, look, the agreement, if I can just have a moment to take you to the agreement. Supplementary bundle, page 66.
Yeah.
Is the dispute resolution mechanism, clause 521. That's the agreement between the parties.
Yeah, but 6 is an agreement to submit to arbitration. 66 is not an agreement to submit to arbitration. It's an agreement to give one party a choice as to where to go.
It's an agreement. Well, yeah, it's an agreement which gives the contractor the ability to go to this dispute, this mechanism, and the NHS will abide by that. That's 521 in a nutshell.
So section 6 covers agreements which include a unilateral option for referral by one party only to dispute resolution.
NHS where the conditions are met.
what 521 does is NHSE agreeing to submit matters to arbitration where the condition is met, and the condition,
So the contractor so wishes, even if the PCT does not agree.
well, the NHSE has agreed to have matters go to arbitration if the contractor wishes. That's what the parties have agreed.
I can get this for it. It's an arbitration on mutuality, which says mutuality is not required.
Well, I'm grateful for the point. The specific question you asked is not one which would specifically turn our mind to on this, but I'm told this specific issue is covered in Russell on arbitration, and there is more on it. The Russell on arbitration covers the issue of what's called mutuality.
Okay, so it's a bad point then, all right, I'll
Well-
assume that an agreement which says even if you don't agree, it goes ahead, falls within an arbitration, because you've agreed that ultimately we'll get to arbitration by some means.
If I can, well, if you look at, I'm not saying, the matter is covered in Russell on arbitration in paragraph 218.
Yes.
Okay, well, that's fine then.
I'll give you some references to get through this quickly because I want to get on to make sure I've got time for both points. If you want to see the way this issue arose, it was the appellant who raised the issue of bringing an arbitration appeal, not the NHSE. And I'm not going to take you to it simply because of time. I've budgeted myself 3 more minutes to cover arbitration, but I'm not sure I'll necessarily meet that.
Is it really necessary? If it is arbitration, does it matter? Say we're against you on your principal point. Say we decide, no, you're wrong on that. The nature of the decision here is public. It's a statutory source, and it's public, and it's judicial review. Even if there's arbitration, that wouldn't prevent it being judicial review. This is only just a point, isn't it, to say that although they say we must find judicial review because there's no private law remedy, there is a private law remedy. It's at that level, you're not saying because it's arbitration, it can't be judicial review. It could be judicial review and arbitration, could it, on your submission?
Well,
I wonder how far we need to go into it.
it's a very fair question, and we made the point before that Section 69 of the Arbitration Act, and indeed other provisions of the Arbitration Act, 768, have points you can bring on arbitration appeal, and that's the remedy issue.
Yeah.
It's also relevant to this case in 2 ways, and I'll just deal with them very, very briefly. One, the first one I've covered, which is the remedy. The concerns being expressed as remedy, we say that's the concern is misplaced because there is remedy here. It's not just error of law, but there are other numerous points you can take to arbitration, 66, 67, 68, 69 of the Arbitration Act. The second way this is relevant is it's instructive and part of the amenability analysis. The court has been taken to several cases that say that talk about the classic case of a body not being reviewable as an arbitral tribunal. So if this is an arbitral tribunal, even if it's a statutory arbitral tribunal, that tells you a lot about function. And we say that's highly relevant to amenability. Which is our concern about bypassing this point. And I can understand the reluctance to get into a legal issue if it's not strictly relevant, but we say it is part of the amenability analysis. if this is an amenable tribunal, then that does pose questions as to having judicial review sitting alongside that, on top of that. And as an example of the difficulty, if you have both applying, if we're right, and this is an amenable tribunal, then your route there on appeals on through section 69 comes with some limits. Those include section 11(3)(b), which is not taking points that were not before the arbitral tribunal, or I summarise. So it would be surprising if you've got two systems that have different boundaries on what can be done, and judicial review can be used to, well, it would be too strong to say circumvent, but to do things which you wouldn't be able to do through the route which Parliament provides, if I can put it that way.
It does have JR then. Section 69 of the Arbitration Act implies the section 31 of the Penal Courts Act as well.
That's appeal on the point of law. What we haven't got in the bundle, I apologise, is 67, 68, which include other forms of appeal, including excessive jurisdiction and other matters. So, but the point is that the Arbitration Act, if we're right, this is an arbitral tribunal, it comes with specific statutory routes and statutory mechanisms, and it would be surprising to also have judicial review alongside that, which is subject to none of those conditions. So that's why we think that the arbitration issue is actually relevant and an important one, as painful as it is. I've got to short circuit the issue, so I'm not going to, if you want me to take you to the cases, Danish Canaria and Baker, which talk about these factors, then I certainly can do. I've got the
Wisconsin, I think, aren't they?
but the quickest way I can do this is by reference to our skeleton, and page 34 sets out factors to sets out the matter to determining whether something is actually an arbitral tribunal. Now, bear in mind, the issue is not whether we think it's a good thing or a bad thing we want or don't want, it's whether it is. No. So if you've got the same pagination, you should have a list of 1 to 9 over page 10, 10 matters. And those come from the cases mentioned just before, and you've got in the bundle Danish Canaria and Baker, which boils the case law down into these 10 matters.
So this is paragraph 82 of your
Yes, indeed. Thank you. And the issue is whether those exist or not. Not whether we like them or not. And you say that for most of this is tolerably clear. Now, I'm not going to go through all 10, that would just take too long. But just to give you a flavour of where this comes from, at that paragraph, we've got what the factors are, and they all come from Danish Canaria and the cases we mentioned. And then also over the page at 82, C for Charlie, we respond to points against us. I mentioned that because I'm not going to have time to go through each of these points. And just to give you an indication of how this works, the first factor, itemised list 1, parties have a proper opportunity to present in that case. That is the case here, because regulations provide for that in the beginning provision. And second point, not receiving unilateral communications from parties. Well, it is the case because Regulation 83 provides for that expressly. Now, I could go through the rest, but unfortunately, I don't have the time available. So we say each of those matters is met, and you can find them in the regulations. and to the extent that the other side disagree with us, well, you've got 82 capital C. I'm just going to touch on two of the points, which are the ones that my own friend mentioned yesterday. One, what he called the phone a friend option, and two, partiality or bias. And the first one, we call the phone a friend option. Well, what my own friend calls the phone a friend option. This is at 82 capital C, subparagraph 5. We don't think there is anything in this point. The subject matter of the dispute is determined by the referral. The ability of the adjudicator to seek advice from a third party is entirely consistent with arbitration. And you can see that in section 37. If you want, I'll just give you the bundle reference for that. Section 37 is on Authorities Bundle, page 35. It's an arbitral tribunal may appoint experts, legal advisors, assessors, and so on. So there's nothing unusual about what my friend calls phone a friend. The only other point which you touched on is partiality or bias. And I'll make the points quickly without going to cases, without going to the authorities, but I'll give you the references. The first point is the relevant issue is impartiality rather than independence. And I say that because of what we know about the Secretary of State being the point of referral. And if you want to see where that is impartiality rather than independence, that's in the Danish Canaria case, tab 67, Authorities Bundle, page 1364, paragraph 46. It sets out by reference to another case. Second point is, it is part of the system here that we do have impartiality within rules. It's regulation 83 bracket 15, which is the adjudicator must proceed in a just, expeditious, economic manner and so on. And so the adjudicator is required by the regulations to proceed in a just manner. And we say that encompasses the concern about partiality. And one further reference on that, if you want to see how that actually operates, Supplementary Bundle, page 211, paragraph 31. The third point is looking at our case in particular. Dr. Shashikanth said he was referring this to the adjudicator because he wanted an impartial, independent party to determine the matter. So that's why he was choosing this. So that was his case, and that's Supplementary Bundle 186, paragraph 149. So if he had concerns as to partiality or fairness, well, he was saying the opposite before. Throughout the process, there's never been any expression, any concern about partiality. And indeed, even bringing a challenge to the decision, there's never a concern or suggestion about bias, partiality, anything of that nature. So we say all those 10 matters by which you decide whether this is an arbitral body, arbitral tribunal, apply in our case, and we've given you the references there. So it may not be what people were expecting, or it may not be what was first thought, but it may also be the case that the sporting bodies subject to this case law didn't know there were arbitral tribunals until the court told them. So that can sometimes be the way the law works. So we say that this is an arbitral tribunal, whether it was thought of before to be that or not. And that is relevant, the way you look at the amenability of judicial review. That is as much as I've got time for on arbitration, unless there's anything I can assist you with or anything that's of concern on that point. Then come to the last point on variation.
I hesitate to say it, but I think you're going to have to deal with this pretty quickly in order to leave proper time for
Yes,
response.
And variation is well, it's a short point, actually, isn't it? It either is a variation or it's not.
well, there are 2 points. One, whether it can be raised when it wasn't raised before the adjudicator, whether it can be raised for the first time on judicial review when it was not part of the dispute, and the substance. So I can
Well, you covered certainly in respect to the first point some of it this morning.
I have covered some of it, but I would like to make a few further points, if I may, on this. That it can be broken up into 2 matters. One, the factual question that the variation issue was not a matter that was referred to the adjudicator as part of the dispute.
Do you want to show us the documents that you rely on for that submission?
Yes. The supplementary bundle.
Am I thinking, right in thinking that 152 of the supplementary bundle is confirmed?
Yes, 151 is the number in my notes, and that's the bottom of 151 is the start of the email making the referral. So you're absolutely right to say 152. And 152, the bottom says further representation will follow once my solicitor communicates with solicitor knows to see.
So I'm writing to appeal the termination notices.
Yes.
The issue before the adjudicator was do the other termination notices when the thing before.
And then the submissions, 153, and you know I warned you that in respect to a witness statement. The relevant issue, the failure to cooperate issue, which is the breach of concern that starts at 176. And this is the duty of cooperation, the para 15A point, failure to cooperate.
So what document is 176?
176 is Dr. Shashikanth's
Statement.
lawyer's submissions, his barrister's submission.
Is the witness statement to the body making the decision? Then, yeah, okay.
It's a submissions. This is the point I was making before, that they're interspersed. It's the continuation of what starts at 153. It's written submissions on behalf of Dr. Shashikanth.
Well, is it? No,
No,
it's his
no,
witness statement by the doctor. If you turn to page 154.
You mean the
And
witness
that's how
statement?
This is the point I was making yesterday, that they're interspersed. They've been jumbled.
It's a bundling error.
It's a bundling error.
Right. So which page do you say we should look at?
176, which is part of the written submissions. And if you want to see, if you look at 187, you'll see the end of that document.
That can't be right, you see,
It's
because
just not right.
page 153 is page 1 of the written submissions, and that ends at paragraph 3. Page 176 is 83, and that oddly follows on from 82, which appears to be part of the written statement. It would appear to be a bundling error.
Lord, I am afraid I'm going to have to admit there is a bundling error here.
If I can show you.
153 goes straight to 159.
Exactly, yes. That's the continuation.
I am sorry about that.
What has been wrongly interspersed is 154 to 158. They've been shoved in
Where
the
they should
middle of the
Ah,
submissions.
right, okay.
So it goes from paragraph 3 on 153 to paragraph 4 on 159.
Right.
And so, in fact, the bundle index is wrong as well.
I'm sure that's
So
right.
isn't it just easier if we just...
Yes. It's 176 is part of the submissions of Simon Butler, barrister, which is the dispute. What he's saying is being what Dr. Shashikanth is asking the adjudicator to determine. And if you look at 176, the failure to cooperation issue, which is paragraph 15A, the paragraph 15A issue is duty to cooperate. 83, approach adopted by the CCG in respect to failure to cooperate, breach the contract, reasonable decision or circumstances. 84, there's no dispute between the parties. Dr. Shashikanth is under a contractual obligation to cooperate with the CCG with respect to enhanced services being offered. So there's no dispute about the corporation duty, corporation duty existing or being imposed on him. He's under the corporation duty. Everything else thereafter talks about why he shouldn't be regarded as breaching the corporation duty. But whether he was subject to the corporation duty is said to be no dispute. And then if you click on, you can see that the following pages go on about why you shouldn't be regarded as being in breach of it. So what we say is Dr. Shashikanth, through his barrister, specialist in this area, sets out what the dispute is, what is for the adjudicator. He says there's no dispute about being subject to this duty, but he didn't breach it for these reasons. That's what the adjudicator is asked to determine, and that's what he does determine. So he accepted being subject to the duty. No issue raised, not part of the dispute about how paragraph 15A applied or didn't apply. It was about breach of the duty. The point raised in the judicial review claim about the validity of the contractual variation in the terms of 15A was not part of the referral. He said the opposite. He said there's no dispute about being subject to the duty. So the first point we make is, well, it's not immediately obvious to see there's an error because Jonathan Haley, adjudicator, resolved the dispute. He was presented with a dispute, whether this duty was breached, he resolved the dispute.
But I do understand that. But, and it's the but. This doctor went to the adjudicator and said, I shouldn't have had my contract terminated. And everyone seemed to have thought that they were deciding whether paragraph 15A, whatever, had been breached. And as a matter of fact, what the adjudicator should have said is, hold on a moment, this isn't part of the contract at all. Because it isn't part of the contract on this analysis. Obviously, we've got to decide your second argument, but assume for the moment you lose it. There's something inherently unattractive, isn't there?
Well, what?
You're saying, when a man goes to say, I shouldn't have had my contract terminated, and the adjudicator says, yes, you should. And in fact, when you look at it, the adjudicator was wrong.
Well, if parties determine what they want to submit to a third party adjudicator, and they say, we've got this dispute over X, we'd like you to determine this, and we don't have any dispute about Y. Please determine X. And this is, we say, it's not inherently inappropriate or unjust that the adjudicator does determine what is the referral. If you look at the contract, which is reflected also in the regulations, 521, which speaks through the regulations as well, it talks about the adjudicator dealing with a dispute. So that's what the adjudicator has, that's what he must determine, and he doesn't determine another matter.
Well, it's quite a core matter, isn't it? Rather fundamental.
Oh, well, he's referred to dispute and he resolves the dispute. And So you know, that is within that is what both the regulations require of the adjudicator to demonstrate, what the contract provides that is mechanism, and that's what's done. And
It doesn't all depend on what dispute grounds, it's all words to describe things, but the dispute is, should he have been terminated? Or more accurately, his contracts have been terminated?
Well,
and the answer varies. I mean, it may be that he was right, that, I don't know, the Data Protection Act or confidentiality overrided. But there's an even more fundamental problem that he may not have spotted as a ground, but the dispute, should he have been terminated or not, depends first and foremost on getting it right that regulation, paragraph 15A isn't a contractual obligation, it's a description of something that should have been made a contractual obligation. So why isn't the dispute, should the termination notices stand, which is what he referred in his email?
because the reference to dispute, the statement of the dispute is very clearly stated on supplementary 176, paragraph 84, by his barrister, there is no dispute between the parties is under this contractual obligation. It couldn't be clearer. It says what's not in dispute.
But I think he means argument there. I don't think he's using dispute in the terms of 82,
Well, look,
regulation 82.
either way, he's
There's
saying
no
that's not
challenge,
a
there's
matter.
argument we're not here about is what you would say, however you cast it. The one thing we're not in the room arguing about, Mr. Adjudicator, is whether I'm contractually bound by 15A. Yeah. Okay.
Yeah, and you see, it's in writing from a specialist legal advisor. I can understand that there'll be more like can take the point if he was acting in person or situations otherwise, but he's got a specialist barrister setting out what is the dispute, and that goes to the adjudicator, and the adjudicator determines it. And he's told what is agreed. And it said that is an error of law because he didn't go behind the statement of what is agreed. And see, it's not an error of law.
Is it one-off? Can you refer another dispute tomorrow saying, by the way, the termination notices are still invalid because they shouldn't have treated me as bound to comply with the regulation? Is it a one-off arbitration?
Well, I'm not able, unfortunately, to answer that off my head because I would just need to check whether there are provisions about, I don't know. We know there are procedures here and I simply am not able to answer that. But we do know that clause 521, which reflects the regulations, talks about a dispute, and if I can just have a moment, clause 525(3) talks about a brief statement describing the nature and circumstances of the dispute, which is what's done. And so it's those statements of what the dispute is which determine the scope of the referral. And when I'm saying it was unlawful to not go behind the scope of what you're given.
And would your client really want to have the contracts terminated if they knew and were told by a court that although there's nothing we can do about it, you are wrong to terminate?
That goes partly, or that links partly also to the issue of whether it's just to act contrary to the common assumption that was shared by the parties. If you look at I don't have time to take you through it, it's a long document. The witness statement of Ms. Sands, which begins at supplementary manual 223, does go through the long history of the relationship between the parties and the range and severity of the matters and the problems here. And one of the difficulties with this is that you have the NHSE clearly on any view intending to end the relationship. Whether this court says they did so rightly or wrongly is another matter, but they were clearly intending to end the relationship back in, I think it was 2020. And a long way after the termination notices, I think it's about 2 years after the adjudicator's decision, and then once matters got to the High Court on judicial review, then it said, aha, there's a problem with paperwork.
It's not a problem with paperwork. You can't take away a man's livelihood unless you vary his contract, tell him that he's got to comply and he doesn't comply. It's not a paperwork.
Well, the NHSE in 2020 was seeking to end the relationship, believed it had done so, both parties acting under that common assumption. 2 years later, something is done to say, well, that common assumption is wrong.
If it was a common assumption, what happened was your person wrote and said, Section 20, Clause 23 of the contract, you've got to comply with legislation. There's new legislation in force, you must comply with it. And what your person said on this analysis was wrong. You should never have told him that because you've misunderstood and you've missed out Regulation 32 and you're the person making the contract.
Well,
is it a common assumption, or is when somebody's told something and believes it?
well, the 28 October letter conveyed that there is a duty in these terms.
There isn't a duty in these terms. Regulation 15, paragraph 15 does not impose a duty. 32 says you must have a contract which complies with what's described in 15A. 23 says you must comply with legislation. The legislation that you've got to comply with is Regulation 32, not paragraph 15A.
Well, the 28 October letter set out 15A, which is a duty to cooperate.
No, it's not. 15A is a description of the requirements that must be included in that contract. It is not imposing a duty to cooperate. You read Regulation 32, it describes what must be put in a contract. It's not a freestanding duty at all.
My Lord, I'm not seeking to say something different. I think we are making the same point. 15A is a duty that should be in a contract. Yeah, I understand.
Yeah.
Yeah, I get that. That is the terms of contractual duty. There should be a contractual duty in the terms of 15A. He sent a letter with the text of that, and it said that the wording of the letter, and we can go to it, is that there's a new contractual requirement.
But it's not.
Well, I understand.
It's a description of what should become a contractual requirement.
This is the point that the parties were under the common assumption that there was a duty that applied. And I'm not, and this is the point about by convention, that both parties were operating under the assumption that a duty in the terms of 15A applied. That was the assumption they were operating under.
And how did you act to your detriment on that?
Because that was in 2020. Had the issue been raised in the course of dealings rather than 2 years after, NHSE could have addressed that variation issue or that issue 2 years before, 1 year before, certainly before the time of the adjudicator. Could have served a further variation notice. Could have taken a different position.
But they could have done it any time.
And they were the ones with the specialist knowledge. I mean, you mentioned any number of times how this particular barrister had specialist knowledge, and yet this is coming from the clinical commissioning group, who no doubt have taken instructions from a governmental body or something of that sort. If they don't have specialist knowledge, well, who does?
Maybe I understand the point. The issue is that if in 2020 the common assumption that the parties were operating under had been disabused, then matters could be rectified then or thereafter. And I
That's
think
what it is. A failure to draw attention to a party's misunderstanding of the law, which they could have rectified, constitutes a detriment sufficient for the estoppel requirement.
well, because the parties then put to the issue was raised in the course of judicial review proceedings 2 years later.
But the detriment is, what has gone wrong is they didn't change his rights and duties. And they didn't change his rights and duties because they didn't understand their own law. Why is it the assumption?
Well,
they haven't read Regulation 32.
well, we've accepted throughout and in the court below that the effect of Regulation 32 is that an SI doesn't have freestanding duty and it has to be imposed in the contract. The issue is, was the letter of 28 October sufficient to communicate the matters required to be communicated?
No, the letter is whether or not the letter constituted a notice of variation.
Yeah.
And for that, it needed to do two things. It had to say, we're proposing to vary your contract terms and it'll take effect from this date. This letter, on one reading, and we haven't decided yet, doesn't say we're proposing to vary your contractual requirement. This letter, read as a whole, gets it completely wrong and says you've got to comply with the law. The law is in 15A.
Well, the letter says the new contractual requirement and says provides the terms of 15A, and by Reg 32, the terms of that are required to be the same effect as, or a contractual term is the same effect. So the point is the two under the scheme are intended to be of the same effect. So he's given the terms of the duty.
It's not a duty. It's a description of something that must be put into a contract. I've got it in front of me. It does refer to Regulation 32. It says the new contractual requirement, and that's a reference back to the new regulations. It tells them when the regulations came into effect. It sets out the thing, and then it goes on to say, I hope the above extract is clear, and then it goes on to say, Clause 23, you've got to comply with the relevant legislation. The whole structure of this letter is they assume that there are regulations, that's a legislative requirement, and the pre-existing Clause 23 means they've got to comply with it. That's very different from a notice saying, we've got to change your contract because we've got to make sure the contract has provisions equivalent to this in it, and this change in the contract will take effect from Monday next, or Tuesday fortnight.
Well, I can't
You
I can't improve on the wording of the letter. What I can do is point out what I think is an appropriate reading of it.
Yep.
So the letter on 146 about 6 lines down, to support commissions in providing care services, National Health Service Regulation 2019 related for Parliament came into force. I'm writing to you on how the new contractual requirement will affect your GMS contract.
And what is that referring to?
And that is, and it then quotes a duty of cooperation and the terms of the duty. I accept, and we all know the problem with it, that it doesn't do the thing which Lewis has identified, but what it does communicate, and what the parties understood it to communicate, both parties, including Dr. Shashikanth, is that there was communication, there was a new contractual requirement, there's a duty here, and the terms of that duty. And we know the problems with it, but it does convey the terms of what the duty will be.
When does it come into effect, this new obligation?
There's a separate issue on timing, which I've covered at some length in the skeleton paragraph 89. And if I can just take you to 87, paragraph 87.2 on page 4. May affect variation, notifies the contractor in writing, the wording of the variation, the date upon which takes effect. It notifies the terms as a contractual requirement. Then as for stating a date, which I think is the point, upon the variations take effect, the letter stated that it may come into force on that date, such that it will affect the appellant's contract, meaning which being that it was bound to apply immediately. And we also
That's the reference to came into force on the 1st of October, and this is a letter of the 28th of October. So you're saying the assumption within the letter, or the implication, is that it has already taken effect in relation to a duty which the doctor is bound by. That's it.
Lady, we know there's a problem with the letter.
Yeah.
The issue is what is the consequence of the problem, and in terms of it being a date problem, and we know there's a date problem, what are the consequences, the effect of that? And we say,
First thing I've just written down, you can tell me this is, sorry to interrupt. Letter means that the obligation came into effect on the 1st of October 2019. Is that your submission? Just so I got that clear.
well, hang on. No.
Ah, right.
Sorry.
So what's the date?
The date of the letter, which is the submission at paragraph 87.2, bound in contract immediately. What's this thing is bound before he's been told about it.
So on receipt.
Yes.
So what, on a date?
The date of the letter. Well, the date the letter was received, or probably
So
been
in
paid.
other words, on a date which isn't specified.
Well, the date of the letter is specified, but the date of the receipt isn't specified. So,
And it's not
But-
less than 14 days.
well, look, we accept there's a problem with the date. The question is, what is the consequence of the problem with the date?
No,
And does that date?
no, that's not the point. No, that really isn't the point, actually. This is contract. Contract requires you to specify a date. If you haven't specified a date, you haven't varied the contract. And the consequence is that the contract is unvaried and you're not in breach. It's as simple as that. If you enter into agreements with people, if I go to a restaurant and order a pizza and they give me a steak, it's not a question of what's the consequence. I've got a meal, I should go away and be quiet. I've ordered something, you haven't delivered it.
Well, with respect, it's not the position we take.
Yeah.
It's a difference between us on that.
Mm.
And that's the skeleton 89.2.
I think Mr. Auburn, your position is as you've set out in the skeleton
Yeah.
in relation to the terms of this letter and how it takes effect. Is there anything that you need to add in addition?
The point is that we've never sought to run away from that. There's a problem with the letter.
Yeah.
There is. But the question is, does that date issue, which is the point we're now talking about, does that mean that there was no variation, or does that mean that there is a breach of the provision specifying inclusion of date? And we say
That tells you, you're assuming it's different. The provisions tell you how to effect a variation. If you haven't effected a variation, it's not a breach, and can you waive an invalidity? You haven't yet done that, which you need to do in order to make a variation.
well, Well, with respect, we say that the inclusion or non-inclusion of the date is not a matter which means that there was never a variation.
Okay.
That's the point. That's the point we've made below. We still make now. It doesn't mean the variation never came in. At most, it means there's a breach of failure to comply with that provision, but it doesn't lead to the result.
Breach of contract by your client, and the consequence is.
Well, the consequence in this case is immaterial because it was never, because he certainly had it for much longer than 14 days. There was no enforcement within 14 days or indeed months after. Nothing happened in consequence for a much longer period. There was nothing that occurred in relation to that which made that notice period material. So at most there was a failure to comply with the requirement, which is not material to the operation of the provision.
And so, in a nutshell, just so that because I think we do need to move on. In relation to the latter, you say it is a valid variation. There was a problem with the date, but that is by the by.
And with the terminology we accept.
And the terminology, which is by the by also, because no one was under any illusion. It was there, the terms of 15A were there, and thereafter there was no enforcement within 14 days or a much longer period than that. Everybody knew what they were up to, and that's that. So in a nutshell, that's what you're saying.
Yeah, with two short points further. The structure of the scheme by Regulation 32 is such that the term of the SI is to be affected in the substance in the terms of the contract. So there was no difference in substance between the duty as set out in the SI and the duty as applied as contractual term, and that's relevant to materiality and so on. And the second point is that not only the parties under no illusion, but it was positively said that they accepted that there was this contractual.
So that's your position in relation to the effect of the 28th of October letter, and you consent that you've covered that with us.
And I've also made the points
That is-
about it wasn't raised in Appellant and Scotland. And so
And then there are the other facets of the moving parts of this part of the case are it wasn't raised and therefore it wasn't before the adjudicator. It
So no
was
error.
accepted. You say that's an estoppel by convention. I think we've bottomed what you say about that out.
we say firstly no error.
Yeah,
It's not an error to not deal with something that wasn't in the
yeah,
reference. And
yes.
secondly, so by convention.
yeah. And then another way of thinking about this, which occurs to me, is are you saying that in effect there was a concession before the adjudicator on the part of the doctor, and therefore he's stuck with his concession? That isn't something that.
I think that's another way of packaging the previous 2 points.
Okay.
I wouldn't. I mean, whether you call it a concession, it wasn't part of the dispute, and the parties expressly said the opposite.
Okay. Fine. Is there anything else that you think you need to say in relation to this aspect? Because I do think we.
I think I'm done. But if I can
Yeah.
just have a moment.
In relation to the variation, I just want to record that we understand the proceedings.
We haven't at all discussed the Reg 84 typographical error point. I'm not going to say anything about it. I just want to.
Oh, section
make-
90, subsection 5.
Yes, at some point we might need to just be clear on what the parties' positions on that are, because you might want to be sure you know. My understanding is it's been conceded by the appellant, but
We're not relying on that section to argue about amenability in the way that we were in the appeal skeleton.
the regulation still stands in the statute books as operative from 2015 to 2024, and
Yes,
will
exactly.
continue to do so.
There was no retrospective change.
Not that I'm aware of.
Yep.
So it's why we thought it was important to deal with it, because it's still on the books.
Well, if that section meant what it meant, or seemed to mean, and if it was enforced, it would undermine completely your argument that this was a contractual thing, and the nature of the decision was not public law, because on one reading, the effect of section 9.5, if it applied, was that it wasn't contractual anymore.
I'm not.
And if
yeah.
that's the case, that would be much stronger for Mr. Shashikanth. Now, it's not going to have anyone after the 27th of May 2024, because they finally said, without saying what the position was before, that after the 27th of May 2024, that's not the law. But there is a very interesting question as to whether a court can say that something that's black and white is an error and it should mean something different. And I wonder whether one way around it is to say, would we say this was public law judicial review ignoring section 9.5, and if Mr. Sachdeva wins on that, then he's home and dry. If he loses on that and he's just said he's not relying on section 9.5, maybe that's enough for us and we can say we've had a lot to worry about, we don't have to worry about that. Maybe that's the way to do it.
I'll leave it in your hands. I just want to make sure that that wasn't forgotten, because it's quite a serious matter
Yeah.
to be stating that there's an error on the statute books.
And also might affect other people who are not before this court.
It's still applicable for 2015, 2024, as far as I understand.
Yeah.
Unless I can assist you further.
Thank you very much indeed. Mr. Sachdeva.
Thank you very much. I have a number of points, but I'll take them shortly. We've supplied the statement of facts and grounds by email.
Yes, thank you.
On the NHSLA, they did positively concede jurisdiction pre-action. We sent you the letter of the 16th of July 2023, which is loose. And I would like to just very briefly go to page 223 of the supplementary bundle. This doesn't, of course, mean you don't have to decide it. But I think the point...
Sorry, supplementary bundle 2 to 3.
Supplementary bundle, page 223, which is tab 11. Do I mean that? Hold on.
Yes, you do. Really Sands.
No, it's a letter actually. It's the. I think I mean 270 actually.
September.
No, that's the wrong letter. I am sorry.
Yes.
The letter of the 23rd of July. 2023, I think. No, it is in the bundle. First respondents. Response 20 July. No, it says 203 in the index. Let's see if it is 203.
23rd of July, DAC
Yes.
Beechcroft.
That's it. So
Okay.
we look at, thank you very much, page 210 to 211. Paragraph 26. And this is relevant because my friend Miss Richards, who pointed out the quotation from McLaren, and I blame her for me not picking it up because she was my people supervisor. The relevance at paragraph 26 is there's a concession in, so this is a response from NHSLA to the letter of correction. It therefore has a role under section regulation 81 analogous to a court or tribunal of resolving disputes between parties, which is exactly what's said in McLaren. It's not self-interested in the outcome of the dispute. PCA will explain the reasoning, does not presently intend to engage further. Paragraph 27, section 9 of the Act provides for a dispute resolution apparatus for a GMS contract and any other NHS contract that sits outside the courts. So you'll recall in the previous paragraph there's reference to regulation 82.1. So that's for so there's reference to both means of referring the dispute, both types of contract, 82.1 and section 9. This will be relevant when any of the PCA's findings are called into question on their merits. Clearly, the PCA is subject to the supervision of the courts, as is any public body. It must act within its powers fairly, reasonably, and so on. We do not dispute the determination question is amenable to JR and public law grounds. And that's not just bad faith and fraud. So this is an explicit concession that from the NHSLA that they are amenable to review, and this is actually 2 JRs, not 1, properly analysed. It's a JR of NHS England, between the claimant and NHS England, and it's the separate JR of the NHSLA with NHS England as an interested party. And I know it's issued on 1 form, and it was fine, but really in principle it's 2 JRs, and where the defendant has conceded jurisdiction and the interested party isn't so sure about it, I'm not sure a judge has to determine that issue. If it's conceded by the defendant, that might have been the short way through all of this, one might think. But it is highly questionable whether it was in truth an issue before Mr. Justice Bourne, properly analysed. But we are where we are, and
I think it is, because it happens all the time, for example, in planning, where the Secretary of State concedes they got it wrong, and the planning developer says, oh no, you didn't. And
right.
the planning developer continues to fight the last
Sure,
ditch, like World War.
There's some money involved, isn't there?
And then they're told politely, of course we have to determine it.
Yes.
Conceded it, and he was right to do so.
Well, in private law, that's not how it works, because a concession by a defendant, the defendant against whom the allegation is made, renders it conceded. And it's obviously true that the first defendant didn't formally concede amenability in the acknowledgement, but they came quite close to it. They certainly said they weren't going to dispute it. And we keep talking about disputes the whole time in this case. The first defendant at no point disputed amenability.
Well, you would say, I imagine, that they couldn't dispute the claim, because the claim was for both NHS England and NHS Litigation Authority. So the best, or they could have conceded part of the claim.
Could have conceded amenability.
Yeah.
And actually, that's the bit that concerns them.
Yeah.
And NHS England might have dealt with the merits, which is the bit that concerns them. Anyway, there it is.
There's
Just-
also, sorry to
My lady,
stop
yes.
you, there's also a separate point, just in that sentence in para 27, clearly the PCA is subject to the supervision of the courts, as is any public body, and this is the bit, and it must act within its powers fairly, reasonably, and so on.
Yes, so it must get the obligation in relation to 15A right.
Yes,
It must
that's
act with-
exactly it.
Yes.
Yes.
It has a duty to decide the law.
Yeah.
But the Jersey point is unanswerable. If somebody's outside the jurisdiction, the court can't simply, the judge can't simply say, yes, well, here's your order enforceable in the county court. If there's no jurisdiction, and why, and we've thrown away the distinction between jurisdictional errors and non-jurisdictional errors some time ago in public law. It's just an error of law is an error of law. The state, so I've said, supplied the statement of facts, and we've gone through regulation, moving on to a different point now. Regulation 32 requires the contract to contain the terms in the regulations, and that the obligation was not incorporated into the contract, not being taken before the adjudicator, is identified in the statement of grounds. I won't ask you to read it now, but that's paragraph 57. The claimant identified the fact this was a point that was being taken, that there was no obligation and it hadn't been taken before. And the second respondent skeleton at page 270 in the score bundle, paragraph 71, I won't take you to it, says there's no error of law in not by the adjudicator if the point wasn't made before him. But it's not saying the adjudicator had no jurisdiction to consider the issue as it wasn't part of the dispute, which is what's being said now. And I say that implicitly conceded that it was a proper point to argue before Mr. Justice Bourne. It sought to argue the point on its merits, and you can't resolve from that on appeal. And at paragraph 73 in the skeleton, the second respondent went on to argue estoppel by convention, but didn't provide any evidence of any significant detriment. And at the hearing, the second respondent conceded, as the judgment records, that the regulation didn't bind the claimant directly, but then moved on to argue the variation point. And that point was argued against the second respondent by Mr. Justice Bourne. And I note what the court has suggested in relation to the respondent's notice, that it doesn't clearly state as an independent ground that Mr. Justice Bourne erred by looking at the point at all, having not been taken before, although it is referred to in the skeleton, but it was quite a hard point to take because they didn't take that approach before Mr. Justice Bourne, so perhaps that's why it was omitted from the grounds where they're in the skeleton. And the question is, what should Mr. Justice Bourne have done in that situation? Allow the Secretary of State's conceded error to remain just because another representative of the Secretary of State says so? And further, it's unsustainable to argue estoppel by convention where the second respondent conceded that had been an error of law before. It is of the nature of looking at it by a concession, and should this court hold the doctor to an erroneous concession of law that was made, that was conceded to have been erroneous. Now, the next topic is the difference, if there is one, well, there is one, but not much of one, between NHS contracts and non-NHS contracts. And the difference is the dispute resolution process. An NHS contract is not misleadingly named in my submission, unlike, I think it was Mrs. Justice Stacey in Hafiz who thought it was misleading to call an NHS contract a contract. It is still a contract, as the legislation makes clear, in particular because all questions of liability under it are determined by means of contract law expressly. The NHS dispute resolution procedure is one procedure, not two, which can be entered into by two methods. For NHS contracts, it's section 9(6) of the Act, and it's regulation 82 for non-NHS contracts. It treats both cases in a similar way. As the court commented yesterday, given that non-appealability of the adjudicator renders the process quite a different type of process, one would expect the regulations to make that clear if that was the legislative intention. But in fact, when you look at the legislation, and I'm not going to take you to the pages, I'll give you the page numbers, there is no distinction in any of the legislation that indicates that the legal position, apart from the enforcement mechanism, is different in any way whether the contract is an NHS contract or a non-NHS contract. And that is required, we say, if the second respondent is correct that disputes in relation to the latter are not to be determined by applying contractual principles. This is the first we've heard of this concept, that NHS contracts and disputes over them are not to be determined by applying contractual principles. What principles, one might ask, are then applicable? Is it mere general fairness? We didn't hear what principles are to replace contractual principles, if that is the case. And yet, my learned friend did seek to rely, I think, on contractual principles when arguing about the effect of the variation, alleged variation, I should say. So my points as to then not the similarity of, or the lack of any items of distinction between NHS contracts and non-NHS contracts in the legislation as follows. Firstly, terminology. They're both described as contracts. Secondly, an NHS contract in section 4 of the NHS Act is described as an arrangement under which one health service body arranges for the provision to it by another health service body of goods and services which it reasonably requires for the purposes of its functions. And that readily fits into a contractual analysis. Now on to the regulations. Regulation 3, page 91, the definition of an adjudicator is the same for NHS and non-NHS contracts. Similarly, Regulation 3, page 93, contract and contractor are defined in the same way for NHS contracts and non-NHS. And Regulation 9(1) repeats the definition in section 4 of the NHS Act for NHS contract. Then Regulation 11(1), which is at page 111, refers to a request that the contract is an NHS contract. So that terminology is quite telling. Perhaps we can just quickly turn that page up, page 111 in the authorities bundle, which is, I think, at tab 8. (11)(1) A contractor may at any time request in writing a variation of the contract to include in or remove from the contract provision to the effect that the contract is an NHS contract. Well, if there was any doubt, that subsection says the contract is an NHS contract. And if contractual principles were not to be applicable to NHS contracts, it would be impossible for this regulation to say what it does. Even if we didn't have all the other points about there being literally no distinction in the legislation, which is a determinative point on its own. Regulation 11.1 makes it clear. Part 5 at page 112 makes it clear over the page that these contractual terms that follow are applicable to all GMS contracts other than the obligation under Regulation 14, which is in Regulation 14 in an NHS contract. The contract must state it's an NHS contract, but it is not an NHS, hybrid concept. It's still an NHS contract. And I know this is beginning to sound boring, or maybe not beginning, maybe it sounded boring at the beginning, but anyway, I do need to make these points because what Mr. Aubin is suggesting is quite revolutionary in terms of how dispute resolution for NHS contracts is apparently to work. Regulation 32 imposes an obligation on NHS England to include provisions in the contract equivalent to parts 6 to 14. Again, that's all GMS contracts. And secondly, the provisions giving the adjudicator, and this is interesting actually, because there was some toing and froing, page 123 on Regulation 32. We've got subsection 1 requiring contracts, and this is binding NHS England, to include equivalent provisions to parts 6 to 14 and schedules 1 to 2 the regs. And then at subsection 2, Regulation 84, which gives the adjudicator jurisdiction, and 83.5 to 15, which is the procedure, are to have effect directly, my word, in relation to the matters set out in these provisions. And they don't need to be in the contract. So the provisions that give the adjudicator jurisdiction are solely statutory. They don't need to be in the contract. But that doesn't mean that they differ in terms of NHS contracts or non-NHS contracts. They are treated in an identical fashion. What is referred to the Secretary of State, whether it's an NHS contract under Section 9.6 of the Act or a non-NHS contract under Regulation 82, is still any dispute arising out of or in connection with the contract. That's the wording in Regulation 82, and Section 9.6 is similar, it's not identical, but it's still disputes arising out of contract in both cases. And Regulation 85, in relation to GMS contracts, and 85 is interpretation. Any dispute arising out of or in connection with the contract includes any dispute arising in relation to terminations. There's no distinction again between NHS contracts and non-NHS contracts. So that's our case for both of them being contracts. No distinction. The only distinction is the method of enforcement. But if there's a dispute in an NHS contract, how is an adjudicator to decide it? Well, the answer is by using contractual principles. And if it wasn't contractual principles, the legislation needs to make clear what principles are to be adopted. And if it's more than that, if actually the whole basis for determining the decision changes, not simply the method of enforcement, one might think that someone might tell doctors that actually it's not just the method of enforcement that's changing, it's the whole basis of the adjudication that's changing. It may not be contractual principles. Anyway, I think I've said enough about that point. It's been said that there were two choices in this case: the choice to adopt a non-NHS contract and the choice to opt for the adjudicator. We respectfully differ with that analysis because the first alleged choice isn't a choice at all. It's the default outcome. If you don't request an NHS contract, if you don't request to be treated as a health service body, you are simply the contract is a non-NHS contract. So there is only one opting in or out in this case, and that was the fateful decision to opt for an adjudicator. And there is similarly one option in an NHS contract, and you've guessed it, what it is. It's your request to enter into an NHS contract. And that's why all the submissions that I'm going to come to about consensual submission to jurisdiction apply equally to NHS contracts, because they have opted initially for an adjudicator and we've opted subsequently for an adjudicator. But the element of opting in is identical. It's just the timing that differs, but the consequence is the same because neither of us, NHS and non-NHS contracts, NHS contracts from the beginning, non-NHS contracts when you opt into the adjudicator give rise to any contractual rights. All we could say is we once had contractual rights. That's the only difference, but we don't anymore. That's the only difference between us and someone who's in NHS contract who's also within the adjudicator. The second respondent, just on the principle, I thought we'd agreed the two main principles of amenability, the source of the power and the nature of the function. Second respondent appeared to resile from that because Mr. Rubin, King's Counsel, said the first question is source of the power, according to my note anyway, and the second question was multifactorial. It wasn't simply asking about the nature of the function. And we respectfully differ from that analysis. We say that there are essentially two phases, source of the power and nature of the function, and then there might be other factors that you can consider to weigh in the balance, but those are the two most powerful factors. And missing from the analysis below is that recognition that that is the general law, which you see from the case law and all of the textbooks. I think not one of them says anything different on that, and nor could they given the state of the case law. So the second respondent says the adjudicator's jurisdiction, and that's an evolution from below where the presence of the contract was emphasised, was mixed statutory and contractual. We respectfully differ from that. The only source of the adjudicator's jurisdiction is statute. It's regulation 84, as I think I've shown the court, and that is not repeated or not required to be repeated in the contract. And in any way, the adjudicator is not party to that contract, so it can't give the adjudicator power over these parties. As to the function, it's clearly public, being the decision of a central government minister about contractual obligations and performance, affecting GPs who have signed GMS contracts and PMS contracts up and down the country. That's the majority of GPs. And there's a wide range of disputes that can arise about the implementation of this very detailed contract prescribed by statute. And so we satisfy the main two tests, and my submission will be in relation to the opting in, we're opting in just as much as a person contracting as an NHS contractor is, and the nature of the dispute, I think that's how it evolved, is a contract law, and in some cases if you're setting up a compensation fund for insurance mis-selling, that might just be a private arrangement. But the context of these types of contracts is it's not at all surprising that it would be something that the courts would wish to supervise the legality of. That's the ultimate question, as Lord Justice Lewis says in his book. That's what we're looking for. Why are we here? Because the outcome of adjudications in these cases is important enough that it engages the supervisory jurisdiction of the High Court. It's because it matters in a public law sense. That's really the case in a nutshell. I think there was reference to the financial ombudsman. They do adjudicate over private law rights. I know Mr. Owen made submissions that the jurisdiction wasn't quite the same thing. They deal with complaints, and it is a wider jurisdiction, and they're not bound by the law, but they definitely do rule on a number of cases which concern contractual rights. And it's never been argued, as far as I'm aware, certainly not successfully, that the financial ombudsman, when determining a complaint that arises out of a contractual dispute, is not amenable to review. So the nature of the dispute as being a breach of contract doesn't intrinsically have such weight as to be able to override the source of the power and the nature of the function. Then I think that I'll just move that to, just give me a second to later on, to take these points out of turn. I'm going to end up with the two questions I was asked to deal with at the end of yesterday, but I don't want to take them any earlier than that. Here we go. Right. Yes, so the nature of the dispute being contractual, it's argued that that is enough to take the case out of judicial review, or that in conjunction with the element of choice. My submission is, if the court took that to heart, that the nature of the contract, in general, breaches of contract that are being judicially reviewed, well, this isn't even that. This is an adjudicator, an inferior tribunal, by their own admissions, judgment on breach of contract. If the nature of the dispute being contractual is enough to take that out of review, that would be a big surprise to quite a few different tribunals up and down the country. It's a dangerously wide doctrine, and it's asking the wrong question, because as Lord Justice Lewis said yesterday, the concern with JR is where the JR is seeking to enforce a contract, and that can cut across their private or contractual right. But here, the JR, the adjudicator, is not seeking to enforce a contract, and it can't be a serious objection to amenability that subject matter of the decision under challenge, as opposed to the grounds of challenge, is contractual. That principle is not contained in any textbook as a principle on a par with the source of power or nature function, and it's not obvious how it could outweigh the fact of statutory power and public function. It also proves too much, because it would mean that you couldn't judicially review any decision maker who ruled on a contractual claim. For a start, the FOS would be out of business, and a number of other tribunals, no doubt. Would that be a good thing? What would be the upside of that sort of ruling? It would also mean that there would be no judicial review of the adjudicator's decision on NHS contracts either, because in reality, there is no material distinction to the amenability of the adjudicator when ruling on an NHS contract and when ruling on a non-NHS contract where there's been an opt-in. So that's the nature of the dispute being contractual point, which is one of Mr. Auburn's 2 points, taking it out of judicial review. Second point is choice. Again, dangerously wide doctrine. Would that mean that opting for a tribunal rather than litigation would rule out judicial review of that tribunal? That would be a surprising notion of in relation to tribunals, and directly contrary to what Lord Parker said in Ex parte Lane, where he talked about the amenability to review of statutory tribunals. That's in tab 16. And it actually refers back to an Electricity Commissioner's case of, I think, 1918. So this is not new, the idea that inferior tribunals are amenable to judicial review. It's not contained in even one textbook, the idea that choice in itself is sufficiently powerful as to outweigh amenability. Again, it would apply to JR, the adjudicator's decision on NHS contracts. And it is contrary to the basic position that everyone has a right to have their disputes adjudicated in court. Another way of looking at amenability, and I know it's not precise in law, is there anything that ousts the jurisdiction of the court? You can look at it as, why should something be amenable to judicial review? Another way of looking at it is, and it might yield the same result, should do, is there anything about the circumstances of the case that ousts the jurisdiction of the court? And there is, the rules on ouster are strict for good reason, and that's why the rules on amenability are relatively liberal, but careful to exclude whenever the jurisdiction is solely based on contract. That's the forbidden area that, although it's not that forbidden, because sometimes the courts do trespass into it if they're interested enough in the outcome, but that's the general distinction. There is also, it's very common that claimants choose to do something they were not compelled to, and that doesn't generally take away the amenability to review of the decision they've sought. For an applicant for benefits, for instance, or for planning permission, or claimant bringing proceedings in a statutory tribunal where it would be possible to go to county court. So the land registration division, I have not been there myself, I understand the land registration division of the first tier tribunal, where a claimant is inviting the tribunal to find a property right exists. It's hard to see why that would stop them litigating if they weren't happy with the outcome. I mean, these are quite punchy submissions that mere choice can take a determining body outside of the ambit of amenability to review. There is also a strong policy objection to the second respondent's position if it diverts cases away from ADR and towards litigation. I know that isn't directly relevant, but it's something court should be aware of. Because if, as seems likely, if the appeal is not allowed, the advice to GP changes to avoid opting in to the adjudicator from a non-NHS contract, there will be many more cases in court, and yet we've seen the Court of Appeal in Churchill and Merthyr Tydfil, that's 2023 EWCAC 1416, holding that the court has power to stay proceedings in order to undertake ADR. The whole move of the courts after Halsey was quite a dramatic change. I think the Lady Chief Justice and the Masters of the Rolls both sat on that case, and it has sent shockwaves through all sorts of places. In fact, I think
Merthyr Tydfil, yes.
yeah, well, I've even done a trial there once, although my opponent didn't turn up for some reason. But even notably, Master MacLeod in her last case has suggested that in cost cases there should be compulsory ADR, which would be a great relief to cost judges. And one can see, I'm not encouraging it, but one can see the point that if the parties haven't had a go to see how they can narrow it, why should the court spend all day trying to get them to do that? But the serious point is that the effect of non-ability to JR of these cases may well, I won't put it any higher than that, influence doctors not to choose the adjudicator, and that's a relevant factor on a policy level. Arbitration, my position remains the same. Either the adjudicator is amenable to judicial review, applying the test for amenability, or it's not. And if the adjudicator isn't, then it's possible that it might be arbitration. That isn't an issue before this court. The jurisprudence you've had cited to you is not intended to distinguish between judicial review and arbitration. It would be odd if there were a case on it, because arbitration is right at the other end. It's at the end of private stroke domestic tribunals, which is already the forbidden area for amenability to review, subject to particular contracts. So whether the Arbitration Act applies is not an issue raised in this case. It wasn't a ground of review. I think my client raised it pre-action. I think NHS England, pretty sure NHS England poo-pooed it at the time. They weren't simply neutral. They said, not sure about that. And it's somehow been resurrected like a phoenix on appeal when it hasn't ever been an issue at first instance. And it is a dangerous path to go down considering arbitration, because the issue for this court is the amenability to review. And arbitration might arise in another case if you rule, for instance, if you ruled the adjudicator wasn't subject to judicial review, in another case, an attempt to appeal might be launched, and that's when it would arise. I would say, in any event, if you do want to deal with the point, which I submit is not necessary, at tab 56, I think that's Russell on arbitration, there is a requirement of impartiality, paragraph 4111, and two of the grounds for finding an arbitrator to not be impartial is, first of all, pecuniary interest in the outcome, and the NHSLA is funded by the Secretary of State for Health, which is the same body as NHS England in substance. And secondly, interestingly, another ground of apparent bias, and it's the same law as we have in courts for apparent bias, if the arbitrator previously acted for or against the party is a relevant consideration, whereas now we have actually the NHS currently acting for the Secretary of State for Health, who is a party in the case. So these are reasons to doubt that this is arbitration. As I say, my submission is the court shouldn't go there. Variation, I'm sorry to jump around so quickly, but I am going to finish in the next 11 minutes. Variation, it's said that my client understood the letter of the 28th October 19 as affecting a variation. That may be true, but the court's job is to construe the letter objectively, not according to subjective understanding of any party. Just on the Mercury-Mauritius duopoly, I think I'd like to phrase what I said yesterday a little bit more precisely. And there are two issues here. First of all, there was a phrase from Mercury that was in fact approved later on in the Mauritius case about never being able to judicially review commercial decisions of state enterprises. And the second respondent skeleton does cite this case at paragraph 60G, and it's probably my mistake. I took that reference as seeking to indicate that commercial decisions of state enterprises are not amenable to review, whereas in fact the Mercury decision was expansive as to amenability, and so was the Mauritius case. And where the two cases indicate something different was that it was quite difficult to judicially review those decisions because the discretion was wide. So I think it's important to look at the two issues, amenability, because Mercury is expansive as to amenability. It found the decision of a state enterprise to terminate a contract was amenable to JR. And I should say, although you won't want to hear this, that we don't necessarily accept that NHS England's decisions to terminate are not amenable to JR, because there is a lot of jurisprudence that says that those are public enough. That the adjudicator should be...
Lost that and you haven't been given permission.
No, not in this court, but we will see in future. But this point should be much easier because it's the decision of the adjudicator that we're looking at. But Mercury said that termination of the decision of a state enterprise to terminate the contract was amenable to JR, and Mauritius confirms that broad approach because the decision in finding condition 15 in that case was satisfied and refusing to sign the implementation decision were also amenable to JR. And this was the contracting party who was being JR'd. So how helpful you find Mercury and Mauritius, I'm not sure they're that relevant, but they are generous in terms of amenability is really where my submission ends. McLaren, my learned friend Miss Richards, cited, I think, pages 409E to F, Lord Justice Wolfe's dictum, where inferior tribunals are generally subject to judicial review. We expressly adopt that dictum, and it's consistent with our case in general, that the adjudicator is akin to an inferior tribunal, as they've said in their own letter on the 23rd of July at paragraphs 26 and 7. Hopley, that was a case about, I've made comments on it yesterday, just to remind you, it's a case about tort litigation against the trust, and the claimant was unhappy. It hadn't occurred to me to do this in tort litigation before. You sue a defendant, you're unhappy with their offer. What do? You judicially review them for not making a generous enough offer. I mean, that is novel on any level. I'm not saying wouldn't rule it out. If someone's done it, might. I don't know how I'd justify it to the Legal Aid Board. That's the only thing. So it's unsurprising that decision is not amenable to review. There's no relevance to the current situation, which is the exercise of a statutory function by a central government minister. But interesting to know about. The West case is the decision of the Business Conduct Committee of Lloyd's, not amenable to JR. The decisions concern the commercial relationship between the applicant and the managing agents, which was it was governed exclusively by the relevant contracts. There was a private act of parliament. That's not the same thing as a public act of parliament. Private acts only bind particular individuals, and there is no parallel. I know Mr. Robin says there's a statutory part and a contract part. Well, the decision itself was empowered by contract alone, and the only type of statute was private act, which has nothing to do with what we're talking about here. Aegon Life case about the IOB having powers solely derived from contract. I'm not going to say anything more about that. Similarly, Moya, power was contractual. Ombudsman's decision not binding on the claimant or consumer, entitled to sue the insurer in the courts, so really nothing to do with this. Two final points. Hussain, my lord asked me about Hussain. It is a non-NHS contract, but you can't work it out from reading the judgment, unfortunately, or you can infer it if you have a bit of legislation at your hand. It was a dispute about pre-contractual terms. Our submission in the end is that Mr. Justice Cranston's findings regarding amenability to review and the applicability of arbitration were entirely correct. I think it was paragraph 47. So the reason we assumed, I think, that it was a non-NHS contract, because that's the interesting thing, if it's a non-NHS contract, is that it was cited at paragraph 74 in the judgment below in that context, because SSP is your example of an NHS contract. And it was a challenge to 4 NHS LA decisions dated 16th of June 2008. And it was about the claimant receiving value for work performed by 4 other dentists who were their assistants. And they had asked for partnership-based contracts that the PCT was only willing to give individual contracts to them. And they signed those individual contracts, but they didn't get the partnership ones. And the difference was they'd be paid for their assistants' work as well. That's paragraph 7. And at paragraph 8, they signed the individual contracts in dispute. And at paragraph 69, those claimants were entitled to and were given individual contracts, just to confirm that the nature of the contracts that had been signed. That the relevant disputes were to do with the value of the individual contracts, that's paragraph 11, and it was held at paragraph 69 that where the work was undertaken by employees or assistant dentists who didn't enter separate individual contracts, this is potentially includable within the contract value of the contracting dentist. So that's paragraph 69. Now, the nature of the contract, the dispute was, this is the clue, paragraph 17, is referred under Regulation 8 of the GDS regulations. And it was to do with calculation of units of dental activity. The relevant regulations are the NHS GDS regulations, and we've sent you a copy of those. You've got a bit in the bundle, not enough. Regulation 8 is entitled Pre-Contract Disputes, and it provides a dispute resolution procedure for pre-contractual disputes. And in the case itself, I think they omit Regulation 8.2, which would have made it clear that Regulation 8.1 is not applicable where both parties to the prospective contract are health service bodies. So Regulation 8 is only applicable in a case of a non-NHS contract. And paragraph 55 of Schedule 3, this is referred to at paragraph 28 of the case, referred to in Regulation 8, sets out the procedure to be followed when the dispute is referred to Secretary of State. So, and it's headed NHS Dispute Resolution Procedure, and it applies both, so you'll see the parallel here, to referral where the contract is an NHS contract, which is 4.3 of the 1990 Act, and paragraph 54 where the contract is not an NHS contract, so the same procedure whether it's an NHS contract or not. And at paragraph 47, claimant agreed, pursuant to Regulation 8.5c of the GDS contract regulations, to be binding. And that applies to disputes referred under paragraph 8.1. So again, paragraph 47 supports the inference that the case concerned a non-NHS contract. And in paragraph 9, they also refer to Regulation 8. So it must be a non-NHS contract in Hussein. And there's another interesting point at paragraph 51. The PCT sought to argue in the JR the claimants were out of time to make reference to the adjudicator, but they then participated in the proceedings for the adjudicator, and the judge held they should have raised it at the time, which is similar to the idea that if you were going to argue that the adjudicator had no jurisdiction to take the legal point he'd got wrong, that had to be argued below. So that has echoes of the argument in this case. Finally, Sibru Rurima. The bottom line, I think my Lord Justice wanted to know whether the referral mechanism in that case was similar to Regulations 82 to 3 of the NHS GMS regs. Short answer is it isn't, because it depends on the terms of the particular scheme, which is a matter of the designated operator. We don't cite the case for the basis that the referral mechanism is similar, but for the proposition that the positive choice of ADR against the OIA in this, before the OIA in this case, in a case concerning usually breach of contract, because that's the relationship between the university and the student, did not preclude JR. And the student's choice in Sibru Rurima to pursue the scheme had no bearing on whether the designated operator was amenable to judicial review. And in that case, there's nothing in the Act that says you can't pursue your claims in the court. and the reviewer only has power to make recommendations. And the bottom line is the facts in this case are considerably more stark, because you could still litigate in that case and it wasn't binding, whereas here it's binding in court and you can't litigate. So the effects of finding non-amenability are much more stark. So if my Lord Justice Lewis is interested, it's section 13(1) of the Higher Education Act. We've given you the whole act, which gives the power on the Secretary of State to designate a body corporate as a designated operator. And under subsection 3A 13, body corporate must meet conditions in Schedule 1 and 13(3)B. The criteria include the provision of a scheme, so the designated body has to come up with the scheme themselves. And Schedule 1 includes, sets out the conditions of that have to be required, paragraph 3 on the body corporate, and Schedule 2 contains conditions A to H, and condition E, paragraph 6, makes it clear the reviewer may only simply recommend but not require any person to do anything. Bottom line is, the details of the scheme are up to the designated operator to devise, and there isn't a similar referral mechanism. My ladies and my lord, unless there's anything further, those are my submissions.
You haven't had the direction, and I was looking. Ah, you got it. Thank you very much.
Oh,
Yes,
good
I
timing.
was given them while he was on his feet, so I couldn't. I've got the direction and the paragraph of Russell, which we were talking about.
Thank you very much. That's
3
helpful.
copies. So I gave them to Ms. Richards while
Oh,
Mr.
right.
Steve was on his feet, so he hasn't. He's just seen them now. So
Just that I'm obsessive. That's the problem.
it's both provisions.
That's really helpful. Thank you very much.
The direction is the only one we've got. It's a 2013 direction, and there's no further direction which has been located.
Thank you,
Two
Mr.
documents there.
Thank you, and thank you, Mr. Sashjeevan. Nothing more. Thank you very much indeed, and thank you to everyone for their submissions, including Ms. Richards, and also to everyone who is behind, who's no doubt worked very hard on this case. You'll be relieved to know that we're going to reserve our judgments. And we will try to get a draft and drafts to you as soon as possible. You know how things work in this court, but I just remind you those drafts are intended for correction only of typographical errors and not a re-argument of any points. Of course, if we've gone hopelessly wrong and misunderstood something, you might draw it to our attention, but not otherwise. But also I must remind you about the embargo, and we take that extremely seriously. The people to whom the drafts will be circulated, their emails should already have been submitted to our clerks. If you want to extend that pool, please ask and explain. Don't just do it, or else the sky will fall on you. And also, as you will also know, or we hope that you will be able to agree at consequential matters, and if you can't, they're dealt with on paper. Please only put in very short written submissions if you can't agree, because length does not necessarily assist. Shall I put it that way? Thank you very much indeed for your arguments in relation to this very difficult and interesting point.